Earlier this month, New York's Department of Financial Services greenlisted a number of different cryptocurrency tokens. And as soon as they did this, the companies who had issued the tokens sent out press releases bragging about having been greenlisted, and a lot of other cryptocurrency companies viewed this greenlisting as very important. But a lot of them misunderstood the legal implications of the DFS's greenlist. So today I want to talk a little bit about the nature of the DFS's greenlist, how a cryptocurrency coin can be added to that greenlist, and why it's a benefit to a company that has a cryptocurrency token to be greenlisted. To understand the DFS's greenlist, you first just have to step back and look at how the DFS regulates cryptocurrency companies in New York. Basically, if you're an individual or a company that is engaged in virtual currency business activity in New York, then you have to get a BIT license. And virtual currency business activity includes transmitting cryptocurrency on behalf of one of your customers, or custodying cryptocurrency on behalf of a customer, among other things. But even once you get a BIT license, it's still necessary to deal with the DFS as your regular prudential regulator. And the DFS previously had required companies that had a BIT license to get prior approval before making use of cryptocurrency coins that hadn't been included in their application to get a BIT license. But the number of cryptocurrency coins kept going up and up and up, and over time that didn't make sense. It wasn't practical. So the DFS adopted this Greenlist procedure, and the Greenlist procedure allows entities that have a BIT license to make use of cryptocurrency coins that are on the Greenlist without first getting prior approval from the Department of Financial Services. There are a couple of ways that a coin can get greenlisted, and the DFS actually lays this out on a handy chart that's on its website. Basically, the New York Department of Financial Services tracks coins that are authorized to be used by entities that hold BIT licenses. And once 3 different entities have all been authorized to use a specific coin, it's then eligible for the greenlist. And in addition, if one of the regulated entities itself issues a coin, that coin immediately becomes eligible for the greenlist. Once the DFS determines that a coin is eligible for the greenlist, it makes a public announcement of this, and there's then a 6-month period during which the public can comment on the nature of that coin, and the DFS considers whether or not to greenlist the coin. And at the end of that 6-month period, the coin might just get greenlisted by the Department of Financial Services. While greenlisting may sound like a green light to use a cryptocurrency coin, it's important to keep in mind we're talking about financial regulation here. So this is a green light, but it's on a highway with lots of other red lights. So for example, it only applies to New York. Other states aren't bound by New York's green list. And similarly, the green list doesn't bind the federal government. So getting greenlisted doesn't have any impact on whether or not you're permitted to use a coin under federal regulations. And finally, even in New York, it only applies to businesses that actually have a BIT license. If you don't have a BIT license, even if a coin is greenlisted, you still can't use it. And to date, there have only been a couple dozen companies that have received BIT licenses in the state of New York. So just because you have a green list does not mean there's a green light for everyone in the cryptocurrency business to start using that coin however they want. While the direct legal benefits of greenlisting are limited, the practical benefits can be huge. First of all, while other state regulators aren't legally bound by New York's greenlisting determination, they do tend to respect New York's review process and are much more comfortable authorizing the use of a coin once it's been greenlisted by New York's regulator. Similarly, even foreign jurisdictions tend to put a lot of weight in determinations by New York's financial regulators. So I've spoken to attorneys who are former regulators and deal with regulators in foreign jurisdictions who have repeatedly stated that those jurisdictions are more likely to authorize the use of a coin once New York State's Department of Financial Services has signed off on its use. And finally, private entities are more likely to become comfortable using a cryptocurrency coin once it's been greenlisted. So for example, a company is more likely to invest in another company that holds a significant amount of the cryptocurrency coin, or even directly purchase a large amount of the cryptocurrency coins and make use of those coins in its own platform once the greenlisting process is complete. So the greenlisting process can be difficult. It can be very challenging. Not everybody who applies is able to succeed in being greenlisted. And the legal benefits also can sometimes be unclear, both to the company that issues the token and to other companies who want to make use of the token. But good news, I'm a lawyer. So if you have questions about the greenlisting process and you're interested in taking advantage of that process, give me a call. I'd be happy to talk to you.